Puan Hanis Tun Hussein from the Noah Foundation, distinguished guests, ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Good morning. On behalf of the Tun Hussein Onn Chair in International Studies, the Noah Foundation, and the Institute of Strategic and International Studies, ISIS Malaysia, I have the pleasure to extend a warm virtual welcome to the third public lecture of the Tun Hussein Onn Chair in International Studies at ISIS Malaysia by Datuk Emeritus Professor Dr. Shad Saleem Faruqi. The topic of today's public lecture will be on federal state divisions of powers, thoughts for the future. The public lecture will begin with a presentation by Professor Shad, which is scheduled to last for about 20 to 30 minutes before proceeding to a question and answer session for 45 minutes. As a matter of housekeeping, please note that we will only be taking written questions through the dedicated questions and answers function or verbally through the should you make use of the raise hand function. With that out of the way and without further ado, I'm humbled to pass the floor to Professor Shad Saleem Faruqi.
Thank you very much, J. Muhammad Haris Zainul, Puan Hanis Tun Hussein of the Noah Foundation, Mr. Chariman Lokman of ISIS, distinguished participants in this webinar. Assalamu alaikum rahmatullah, may peace be upon you all. It's my privilege to address you on this topic of federal state relations, some thoughts for the future. May I begin by pointing out that there is no prototype or model federation, and the 25 or so federal systems operating in countries like the USA, India, Brazil, Germany, and Mexico exhibit many differences. But some generalizations about the essential attributes of federal governments may be made. I've jotted down about 9 or so attributes of federal systems. Number 1, federation is an association of states. Number 2, there is unity of government, one government at the center and one government in the various states or regions or cantons or provinces or whatever you call them. Number 3, the states exist as semi-autonomous units. Number 4, and that's very important, there is division of legislative, executive, judicial, and financial powers between the center and the states. And this division is constitutionally demarcated and guaranteed. Now that's where the main difference lies, Haris, between unitary and federal systems. Even in unitary systems like in England, regional governments of Scotland and Wales and England and Northern Ireland have a lot of powers. But these powers are not constitutionally guaranteed. These powers are devolved, they are delegated. But in our system, the powers of the states are not delegated by the federal government in its goodwill. These powers are given to the state governments by the Constitution, and therefore they are constitutionally guaranteed. Number 5, there is a supreme constitution with federal guarantees of state rights. Number 6, cooperative federalism is permitted, by which is meant that each part of the federal system is permitted to share or devolve its powers on others. So federal government can delegate its powers to the states. States can delegate their powers to the federal government by consent. So this cooperative federalism is a good idea. Number 7, there must be provision for judicial review if the federal or state governments trespass on each other's powers. In an Appendix A, I've listed about 15 or so cases in 63 years of Federation of Malaya and 57 years of Malaysia, where the courts have had to resolve disputes between the federal and state governments. Number 8, the states must have some control over constitutional amendments. The Constitution is the basic law, and it lays down the basic rules of the game. No one party should be allowed to amend it unilaterally in a true federal system. Number 9, there must be equality amongst the constituent states of the federation. Now, with many significant exceptions, some of the above 9 features find a place in our federal constitution, though I must confess a wide gap has developed between theory and reality. May I now go to the Malaysian model, which is a federation with a heavy central bias. Except in relation to Sabah and Sarawak, the constitution creates a very powerful central government that can lead, dominate, and control the states in many ways. Now, I wish to make it clear, this is not meant to be a condemnation of the Malaysian system, whether it is federal or unitary or quasi-federal. I think all is well that works well from the pragmatic point of view. Nevertheless, while I'm not concerned with labels, the point is this: the constitutional design must be looked into. What was our design? Next one, there is an unequal division of legislative power. The legislative powers of the federal parliament and the state assemblies are prescribed in 5 legislative lists in the 9th schedule. I won't have the time to look into all these items. The federal list contains 122 entries. The state list, next one, the state list contains 37 entries. Then there is a concurrent list where both federal and state can legislate. But if both have legislated and there is a clash of laws, then the federal law will prevail. So says Article 75. The concurrent list has 10 items. For example, welfare, scholarships, drainage. Then there is a supplementary list for Sabah Sarawak. That's the next slide. Supplementary list for Sabah Sarawak. Sabah Sarawak have been given some special powers on 7 matters. For example, ports and harbors, and in Sabah, the Sabah Railway. Then there is a supplementary concurrent list for Sabah Sarawak. 9 matters, including shipping, charities, theaters, are in the concurrent list. The overall score is like this. Federal jurisdiction has 132 items. State jurisdiction has 47 items. And Sabah Sarawak have 47 plus 16, so 63 topics. Then there's something called residual matters. Anything not covered in the federal list or state list or concurrent list, anything left out will belong to the states. Now I go to the most important issue perhaps. There is no fiscal federalism in the sharing of revenue or taxes. There is no spirit of equal division. Money, I'm sure you'll agree with me, is at the heart of government. In the financial field, the central government's preponderance of power is very evident. The constitution has been so devised that almost all the important direct and indirect taxes belong to the center. Most of the lucrative sources of revenue are assigned to the federal exchequer. Schedule 9, next slide. Schedule 9, list 1 and list 3 indicate a massive amount of fiscal centralization. Among the sources assigned to the federal government are income tax, sales tax, corporate tax, stamp duty, customs and excise duty, licenses for motor vehicles, banking, checks, bills of exchange, money lending, capital issues, stock, commodity exchange. Next one, subject to state power over licensing, development of mineral resources, mines, mining minerals, mineral ores, and this is a very controversial one, oils and oil fields. They're all in federal hands. Purchase, sale, import and export of minerals, factories, industries, shipping, navigation. So the list is very long. Let me skip the next, let me go to slide 16. What is also noteworthy is that the federal government makes indirect earnings from many items in the state list. For example, though land is a state matter, if you sell your land to me and you are subject to property gains tax and stamp duty, The gains tax and stamp duty goes to the federal government. So though land is a state matter, transactions on land basically are a money earner, not for the state, but for the federal government. If I rent my house to you, rent that I receive is income under the Income Tax Act, and that will be subject to federal income tax, even though actually land or property is a state matter. Now I go to next one, state revenues. The Constitution in Schedule 9 lists 2, and in the 10th schedule assigns some important sources of revenue to the states. The most important are revenues from lands, mines, and forests. So, for example, Cukai Pintu that we pay goes to the state exchequer. That's an interesting one. Toddy shops, that is an earning for the states. Licenses, other than those connected with water supplies. Next one, Zakat, Fitra, Baitul Mal, and similar Islamic revenue. 10% of export duty on tin produced in the state used to go to the states, but now I know tin production has gone down. Next slide, yes, 10% export duty on tin in the states. Export duty on mineral ores, metal and mineral oils also goes to the states. Now, next one, Sabah Sarawak have additional sources of revenue, but the details are very lengthy, so I'll skip that. However, may I point this out to you, Mr. Chairman, it is estimated that all in all, the yearly total state revenue of the 13 states comes to about 10% of the federal revenue. Now that's a real disparity in terms of income of the federal government and income of the states combined. Then federal grants, the states along with their income are also allowed as a matter of right to some federal grants. There is a capitation grant. This grant is based on the state's population. There is a complex formula, ringgit 72 per person for the first 100,000 residents, 1020 for the next 500,000, 1080 for the next 500, 1140 for the remainder. So that's a capitation grant. Then there's a state road grant paid per mile of a state road. Forgive me to use the word mile because that's what the Parlimbagan uses. It doesn't use the word km. Maybe they should change that. In addition, there are other possible discretionary grants. It's up to the federal government whether to give or not to give. There is a state reserve fund from which the federal government may, in its discretion, after consulting with the Finance Council, give money to the states. Contingency grants, again discretionary. Loans, these are discretionary. Now, may I point something else out to you, which when I first came across, really shocked me. In the 2020 budget, next one, in the 2020 budget, these grants and transfers amounted to 2.6% of the federal budget. In the 2019 budget, federal allocation to the states amounted to 2.4% of the federal budget. And the source actually is budget 2019 and budget 2020. So it is obvious that the Constitution has been so devised that it does not provide for true fiscal federalism. The federal government has a preponderance of fiscal power. May I go on to the next one? Next point, federal power over constitutional amendments, except in relation to two topics. Our Constitution is very unique in that the federal Constitution can be amended without any participation by the states, except in two topics. The two topics are, if we change the boundaries of the state, then the state assembly has to approve that amendment. And secondly, if the rights of Sabah Sarawak are to be affected, then under Article 161 capital E, the consent of the governors of Sabah Sarawak must be obtained. I emphasize governors, not the assembly. Now, I'm sure you are aware, governors are federal appointees, so they may not really protect the interest of the states. So the participation of the states in the amendment of the Perlembagaan Persekutuan is minimal. This is in contrast with the USA, where actually once you amend the constitution, if you wish to amend the constitution, 3/4 of the 50 states must say yes. 37 out of 50 states must say yes. Here, we don't have to seek the consent of the state. The best example of that I can give is this. In 1963, Sabah, Sarawak, Singapore were to be brought into the Federation of Malaya to constitute a new nation, the Federation of Malaysia. Kelantan objected to the admission of Sabah, Sarawak, Singapore. Kelantan said, we were one of the constituent units to found the Federation of Malaya. You must consult with us before you change this so drastically. The change was drastic because with Sabah, Sarawak, Singapore coming in, for a short while, Malays would become a minority in their own country. For a short while, between 63 to 65. So Kelantan objected, but Kelantan lost the case. The Kelantan government went to the court, the government of Kelantan versus the government of the state of Malaya and Tunku Abdul Rahman Putra Al-Hajj, and said, our consent must be obtained. And the court said, under which law? There was no law. So the Kelantan said, there is a convention, a custom, a tradition. Court said, well, customs and traditions are not law. They depend on voluntary submission to the customs. And so Kelantan lost the case. Our constitution in this respect is quite unique. And by the way, because of this constitutional amendment power in federal hands, some amendments have been controversial. For example, I'm on slide 37 now. 37, sorry, 37. I mean the mark, 27. I made a mistake, sorry, 27. Tourism at one time was in state hands. It was taken away. It was a rich source of revenue for the states. I'm sure you'll agree with me. Tourism was taken away, transferred to the federalist. Sabah Sarawak have objections to some amendments that have been made. Okay, other modes for federal dominance. Slide 28. Emergency provision under Article 150 can be utilized by the federal government to suspend the state constitution, state rights, state assemblies. That's what happened actually in 1966 when the assembly of Sarawak in 1966 when the government of Sarawak was modified, Stephen Kolangling was dismissed, the constitution of Sarawak was amended. In 1976, the Kelantan assembly was dissolved. So state rights are in this respect at the mercy of the federal government if emergency is declared. And B5, federal power to sign international treaties can undermine state rights. International treaties are obviously a federal matter, and if the treaty touches on a matter in this state's jurisdiction, well, the federal government can go ahead to give effect to the treaty. All that the Perlembagaan says is the state must be consulted. But may I remind you, consultation is not the same thing as consent. Consultation simply means I consult with you and say, thank you very much, but no. Federal power to enact uniform laws even on such crucial topics as land law and local government. Though land and local government are in state hands, Article 76 allows the federal parliament to pass uniform laws, at least for West Malaysia, uniform laws. So I'm sure you are aware the National Land Code is a federal law, though it is on a state matter. Local Government Act is a federal law, though local government is an important topic in the state list. Next one, slide 29. The federal power is there to intervene if there is non-compliance with the federal constitution by a state. Article 71 allows the federal government with one stroke actually, to amend a state constitution if the constitution of the state is not in compliance with the federal constitution. B8, there are several federal supervisory or policy-making bodies whose advice is binding on the states. The National Land Council. So land is in the state list, but there's a National Land Council. And the National Council for Local Government, the National Finance Council, the Auditor General, the Election Commission. Now, I admit that the states are handsomely represented on all these councils and commissions. Nevertheless, the point is this, that these are issues primarily in the state list, but the federal agencies are able to frame policies on these matters. And I have to say this with some sadness, that except for the Auditor General, all the other councils and commissions have not operated in a politically neutral way. They have been rather inclined to give effect to federal wishes. B9, the federal government has control over development plans. Article 92, over inquiries, surveys, and statistics. Next one, public servants. Though the states are theoretically free to choose their own civil servants, many important posts in the states, the designated posts, are filled by federal officers on secondment to the state. So state secretary, state financial officer, the state legal advisor are all federal officers. And this creates a real dilemma. You may be the Mantri Basar of the state, but in the EXCO are sitting federal officers. Now, where does their loyalty lie? To the state government or to the federal government? I'll skip the next slide, Article 75, next one, slide 33. There's an informal de facto federalization of some topics and some services like public complaints. I'm not criticizing the existence of the Bureau Pengaduan Awam. No, it's a good thing to have. But the point is this, how can Bureau Pengaduan Awam, a federal agency, look into matters under state jurisdiction? So there is an informal federalization of matters in the state list. Federal laws like Local Government Act, Official Secrets Act, Printing Presses and Publications Act undermine state power. So for example, several states under the last Pakatan government wanted to have local government elections, but they were not allowed because the Local Government Act is a federal law. The federal government has power to acquire state land for federal purposes. Next one, special position of Sabah Sarawak. Now, some of what was said above does not apply to Sabah Sarawak because of their geographical size, ethnic and religious uniqueness, and the problems of underdevelopment. Sabah and Sarawak entered the federation on many special terms not available to the 11 peninsula states. I will skip the reasons because of my time problem, but Sabah Sarawak have ample justification for their special treatment. May I go to slide number 38. In the legislative list, the supplementary state list confers additional powers on these states in 7 matters, including native law and custom, ports and harbors, and in Sabah, the Sabah Railway. Then there is a supplementary concurrent list for Sabah Sarawak, again giving them some additional powers. Next point, the federal government has power to pass uniform laws for the sake of uniformity for West Malaysian states, but this power is not applicable in relation to Sabah Sarawak. So land, agriculture, forestry in West Malaysia is subject to a federal law, even though it's a state topic. But the power of the federal government does not extend to Sabah Sarawak. So land, agriculture, forestry, and local government are exclusive to Sabah Sarawak. Amending the constitution, the consent of the governors of Sabah Sarawak is needed under Article 161E. Sadly, things haven't quite worked out nicely. In Robert Lingi, the issue was this, that an amendment was made to the federal constitution. We have the provision of a judicial commissioner. These are judges of the High Court appointed for a short term. So these are probationary judges. They're called judicial commissioners. At one time, the law was that judicial commissioners for Sabah Sarawak will be appointed by the governors of Sabah Sarawak. That was amended. So now actually they're appointed by the Yang di Pertuan Agong. So Sabah Sarawak challenged and said, this is a violation of our rights. But they sadly, they lost the case. Then judicial powers. Sabah Sarawak have special judicial powers. Native courts exist along with Sharia courts. There are two separate high courts, one high court for Malaya and one high court for Sabah Sarawak. And the federal, then the Courts of Judicature Act 1964 says that the appointment of the Chief Judge of Sabah Sarawak requires consultation with the Chief Minister of these states. Even though the Yang di Pertuan Agong appoints, the Yang di Pertuan Negeri must be consulted. But again, consult doesn't mean consent. Then appointment of JCs, I mentioned on this point, there is a dispute on this point, but Sabah Sarawak have lost the case. Then, very interesting, lawyers for cases originating in Sabah Sarawak. If a case originates in Sabah Sarawak, then even if it is heard on appeal in Putrajaya, you and I as lawyers, if we are lawyers, cannot appear. Only Sabah Sarawak lawyers can appear in that case, unless special admission has taken place. So there is a monopoly for Sabah Sarawak lawyers for cases originating in Sabah Sarawak. Then representation in Parliament. In 1963, Sabah Sarawak and Singapore had 33% of MPs in the Dewan Rayat. Why 33? Because that would prevent a constitutional amendment. But with the withdrawal of Singapore, now the Sabah Sarawak representation has gone down to 25, which means together their MPs cannot block a constitutional amendment. So they are aggrieved with that their power to block an amendment has been taken away. Emergency powers, I mentioned, during an emergency, federal government can encroach on state powers. But for Sabah Sarawak, there is one concession. Native law or custom of Sabah Sarawak cannot be extinguished by emergency law, even under Article 150. So emergency law cannot extinguish Sabah Sarawak customs. Then development plans. Sabah Sarawak are not subject to federal power over land utilization, local government development, unless with the consent of the Yang di Pertuan Negeri. Policies of the National Land Council, National Council for Local Government are not binding on Sabah Sarawak. So in that respect, on many of these policy issues, Sabah Sarawak have autonomy. Then I go to fiscal federalism. The federal government's stranglehold over most of the lucrative sources of revenue is not as strong in relation to Sabah Sarawak as in relation to other states. Sabah Sarawak have, next one, special sources of revenue. They are mentioned, the list is quite long actually. This is Article 112. And then there are special grants for Sabah Sarawak. For example, sales tax. In West Malaysia, sales tax is a federal matter, but Sabah Sarawak are allowed to have their own sales tax. And I'm sure you are aware, Petronas and Sarawak are in a dispute because Sarawak is charging sales tax on oil exports. Article 153 protection, next one. Next one. The protection for Malays and natives of Sabah Sarawak applies to both actually under Article 153. Immigration, Sabah Sarawak have a right to regulate immigration, not only of foreigners, but also of Malaysians into Sabah Sarawak. English and native languages, Sabah Sarawak enjoy special protection in relation to the use of English and native languages, and they have so many native languages. Malay reserves do not apply in Sabah Sarawak. However, yes, they have native land. They have native land. Though please do bear in mind that the Malays are part of the definition of natives. But so Malays will have right to native land. Malays as natives will have a right to native land, but there is no Malay reservation land in Sabah Sarawak. Now, developments in Malaysian federalism. Now I'm looking at what has happened in the last 63 or 57 years. 63 years after Merdeka, 57 years after Malaysia Day, not all is well with the relationship of the states with the center. May I go to Sabah Sarawak's main grievances? This is a controversial area, and we will try to be as politically neutral here as possible. Sabah and Sarawak say that their 20 and 18 points have not been fully honored, especially on the issue of religion, on the issue of language. May I point this out to you, though I know this is controversial. In 1963, there was no state religion in Sabah and Sarawak. Now there is a state religion of Islam in Sabah, but not in Sarawak. Sarawak still does not have a state religion. In 1963, it said, if federal government gives any money for promotion of Islam in Sabah Sarawak, an equivalent amount must be used for welfare in Sabah Sarawak. In 1963, the Constitution said that the ban on proselytization of Muslims in Article 11, Clause 4, no one can preach to Muslims. That ban does not apply in Sabah Sarawak in 1963. Now, Sabah Sarawak feel that the Federation has gone back on these promises. The federally appointed governors have not always protected the special interests of Sabah Sarawak. May I go to slide 55? Now and then, chief ministers in Sabah Sarawak, the Ketua Menteri have been removed. Kolong Ningkan was removed because he was at loggerheads with the then Prime Minister. Pairin won the election hands down, but through clever manipulation of numbers, crossing the floor, his government fell within a few weeks after election. Labuan's federalization is a sore point. There's an allegation that Article 153 is not vigorously enforced for the natives of Sabah Sarawak. Actually, in 153, the special position of Malays and natives, the two are put together. There is no lower position for natives and higher position for Malays. Article 153 applies to both. But Sabah Sarawak can say that it's not vigorously enforced. Actually, in my humble view, 153 needs to be looked into again. As a student of law, I ask myself, does the special position of Sabah Sarawak apply throughout Malaysia? Or does it apply only in Sabah and only in Sarawak? So I think that's an issue that needs to be examined by constitutional experts. And may I also point out, I apologize, I left this out, but while revising this morning, this point occurred to me. In 1963, when the Perlembagan was amended to to create a new federation, Article 1, which describes the name of the country and the territories, Article 1, Clause 2 said, the federation shall consist of A, the 11 states, B, Sabah and Sarawak, C, Singapore. So there were three separate categories of states. In 1965, they amended that to say federation shall consist of 1, 2, 3, 4, 5, 6, 7, 8, up to 13 plus federal territory. So those two categories. Singapore was, of course, taken off in 65, but even Sabah Sarawak's special category was removed. So Sabah Sarawak feel that this kind of submerging of Sabah Sarawak into the federation like that was a diminution of their status. By the way, the Pakatan tried to restore the pre-1965 amendment. Sarawak voted against it. But, they voted, they said it's nominal, it doesn't really, they wanted further amendments to clarify other issues. I'll skip the next slide. Slide 57. Native custom and Sharia law are often in conflict. We don't talk much about it, but actually in Sabah Sarawak there are both native courts and Sharia courts. And as I was mentioning to you earlier, Malays are part of the natives of Sabah Sarawak. Sometimes when a case comes up, the Malay Muslim prefers to go to the native court rather than to the Sharia court. But actually the state law says if a person is a Muslim, the case must go to Sharia courts. So there is this, legally there is no problem. Legally the law is clear. It goes to the Sharia courts. But what is happening is the parties agree to go to native court. The native court gladly accepts jurisdiction, and therefore this unique situation is there. Then there is a submission by some Sabah Sarawakians that in 1988, Article 121 brackets 1 capital A was inserted to make Sharia courts immune from the jurisdiction of civil courts. Sharia courts were raised in their status. Civil courts cannot interfere. Sabah Sarawakians are saying, you must do the same to our native courts. Native courts should not be regarded as subordinate courts. They should be on par with the Sharia courts. Now that's their demand. Next one, petroleum. Oil and oil fields are in federal hands. This is a very contentious issue, and I know that many learned people here in the audience will disagree with me on this. I'm just trying to mention what the Perlembagan says. Oil and oil fields are in federal hands. Only import and excise duty on petroleum products are in state jurisdiction. So import duty, excise duty on products are in state jurisdiction. Royalty rights of Sabah Sarawak are not derived from the Perlembagaan, Persekutuan, but from Petroleum Development Act, Petroleum Mining Act, assignment deed between the states and Petronas. So there was a agreement signed, and it is their 5% actually comes from this agreement. There is a demand from them to increase the royalty from 5 to 20%. Sabah and Sarawak's power to impose sales tax on petroleum sales has caused controversy. Recently, Petronas Chief Executive Wan Zulkifli Wan Arifin, former chief, was reported to have resigned over the federal government's plan to pay 470 million in sales tax to Sarawak. But on this point, I have to say, the Perlembagan clearly gives to Sabah Sarawak a right over sales tax. Now, next one, federalization of critical state matters such as water and tourism has taken place, and this has caused a lot of grievance. Declaration of emergency in 66 to topple Kolong Ningkan. The strength in parliament in 1963 was 35%, now it is only 25%. Borneoization of the civil service is proceeding too slowly. Illegal immigrants have altered the demography of Sabah. Sabah Sarawakians are unhappy with the Ketuanan Melayu concept. The Kalima Allah issue, whereby the use of the word Allah was not allowed in Christian Bible, has caused a lot of anger in Sabah Sarawak, because in Sabah Sarawak, Bahasa Melayu is spoken much more extensively than in West Malaysia, even amongst the non-Malays. They have used Bahasa Melayu. They were using Indonesian translations of the Bible, and in the Indonesian translation of the Bible, the word Allah was used. So there is some discomfort here, and this is a controversial topic. Then empaneling of the federal court. There was a pre-1963 understanding in the IGC, Intergovernmental Committee report, that when the federal court is hearing a case in Kuala Lumpur or in Putrajaya, at least one judge on the bench must have Borneo experience. This has not always been followed. Recently in a case, this argument was raised that the panel is wrong. The panel must have at least one Borneo judge, and the federal court held that that understanding is not law. So it is not binding. It is merely a matter of what could be called a constitutional convention. But I have to clarify with the learned audience here, conventions are not law. Conventions are practices which are regarded as binding by those to whom they apply, but they are not enforceable in a court of law. They are not enforceable in a court of law. So for example, there is a convention, at least so I think, that in the cabinet, there must always be some women. There must always be at least one representative from each state in the federal cabinet. What if the PM doesn't, future PM doesn't put women or all the states? Can you go to the court and say, this is a convention? No, the court will say, your remedy is a political remedy, not a legal remedy. Now, grievances of the peninsular states, lack of fiscal federalism, I have mentioned that earlier, unequal treatment of states on petroleum royalty for opposition-controlled states. Two governments ago, some states were given royalty, some states were given wang ehsan. They were saying, what is this? It's a right. It's not a wang ehsan, it's a right. So there should be no discrimination in terms of whether you belong to the ruling coalition or you're in opposition. Federalization of water supply. Local authority elections are demanded by some states, but they are not allowed under the Local Government Act. Conflict between federal law and state law over freedom of information. Some states, Selangor, Penang, passed Freedom of Information Act, but Freedom of Information Act is subject to the Official Secrets Act. So there is a conflict. Many states are complaining that Islam, one of the most important state matters, is being federalized through such federal agencies as JAKIM. And I wish to let your audience know that actually even many sultans, their majesties, are unhappy with the slow federalization of Islam that is taking place. There are federal hindrances to international investment in state economies. Many states wish to have international MOUs, MOAs, and contracts. But the problem is, foreign investment must go through federal channels. And the federal government often doesn't permit because it's an opposition state. So I think that's the objection, that there is federal hindrance to international investment in opposition-controlled states. Now, the last part of my presentation, thoughts for the future. All in all, except in relation to Sabah Sarawak, the Constitution creates a very powerful central government that can limit and control the states in the legislative, executive, and financial fields. There is a clear situation of fiscal centralization and lack of fiscal federalism. Policy making and development plans are subject to federal control. International treaties and foreign investment are entirely under federal jurisdiction. Now, such concentration of power in federal hands has some advantages for development goals. Because of the small size of most state economies and the lack of what is called economies of scale, fiscal decentralization is regarded by some economists as a poor option. if you indulge in decentralization, it may not lead to rapid economic development. Then the COVID-19 pandemic illustrated the need for vigorous centralized action. This has to be done at a central level, uniform policies. Many states have handled the environmental crisis very, very badly. If the approaching environmental catastrophe is to be prevented, then firm, centralized, federal, and immediate action is needed. On the other hand, proponents of decentralization argue that despite federal dominance for 63 or 57 years, there is persistence of poverty and underdevelopment in many states due to poor federal planning and inequitable treatment by the federal government of some states. There is serious vertical disparity of wealth between the center and the states, and a horizontal disparity among the states. So two types of disparities: vertical between the states and the federation, horizontal between the states intersect. There is serious influence of partisan politics on budgetary allocations. Opposition-controlled states feel seriously discriminated. The federal control over state economies has significant implications for a state's ability to implement its electoral promises. The state election takes place. The government comes to power. It has promised the electorate certain things. It doesn't have the money. So then why have elections if they don't have the resources to give effect to their electoral promises? I'll just take another 3 minutes or so. The current highly centralized fiscal system has discouraged a competitive environment among state governments. The constitutional councils and commissions do not operate in an independent and bipartisan manner. And of course, we all are aware there are emerging voices of regionalism and separatism, not only in East Malaysia, but even in one or two West Malaysian states. Federal grants to the states, 2.5 or so of the federal budget, must be enhanced. The federation must evolve rules to remit to the states a proportion of those federal taxes derived indirectly from state topics like land. The huge income from the halal harams certification must be handed over to the states. Now, halal haram is surely an Islamic matter, but actually it's being handled by JAKIM. I know JAKIM does allow the state some participation, but why not hand over this Islamic matter to the state? It'll be a supplementary source of good income for them. Now, by way of conclusion, may I just go to slide 73. Leaders of the federal government must recognize that the restiveness of the states, especially of Sabah and Sarawak, is real and must be addressed. Balancing the concerns of equity and efficiency in intergovernmental financial relations is paramount. Petrol royalty issues have triggered separatist movements in many federations. Please do remember Sudan, North-South, Nigeria, Biafra. Don't also forget the sad example of East Pakistan and West Pakistan. It was not over petrol, but over lack of autonomy for East Pakistan, ultimately became Bangladesh. Let not history repeat itself. In the decades ahead, some fresh thinking is needed to repatriate to the states a portion of the earnings from the states on such matters as land, oil, gas, hydroelectric power. Tourism should be, in my view, returned to the states. Halal haram certification is a matter of Islam, should be given to the states. There's a need to strengthen institutional mechanisms for regular, non-partisan dialogue. Next slide. The survival and stability of this federation, especially in relation to Sabah and Sarawak, rests on reviving the spirit of moderation accommodation and compromise that animated the architects of Malaya in 1957 and Malaysia in 1963. If we wish to move forward in peace and harmony and prosperity, I think we need to go back and recapture that spirit of 1957 and 1963. Thank you very much. Assalamu alaikum.
Thank you, Professor Shad, for the presentation. As mentioned earlier, we will now proceed with the questions and answers session of this public lecture. Once again, please note that we will only be taking written questions through the dedicated questions and answer section, or verbally should you make use of the raise hand function. Co-moderating the question and answers session with me will be Encik Syariman Lokman, a fellow at ISIS Malaysia. Prof. Shad, to begin with,
Sure.
We received a question from Archana about your opinion of whether there should be more autonomy given to the states, since our federal government can't necessarily be the most informed institution on the issues faced in each state. Yeah, so you want to start with that first?
Yeah, sure. Actually, the overall thrust of my presentation has been that in 1957, nation building, unity, harmony, economic development was very important. But I think now, with 63 years of Merdeka, 57 years of Malaysia, I think it's time now for some dispersion of power, some decentralization, and I think that would be good. Quite clearly, there are complaints, legitimate complaints from West Malaysian states, from Sabah and Sarawak, and I did try in my presentation to make a number of proposals. For example, I was shocked to discover that only 2.5% of the national budget is transmitted to the states as a grant or as a federal allocation to the states. So I'm totally in agreement with you, Archana, that some state issues require familiarity with the state situation, and I think we need decentralization. May I also point out, Mr. Chairman, that actually decentralization is taking place everywhere in the world. For example, England is unitary, but the Scottish, Northern Ireland, Welsh governments are so powerful, but that is actually devolution rather than constitutional federal division of powers. And may I point this out to you, in some countries, local governments are more powerful than our state governments. In Australia, the local governments, the Majlis Perbandharan, actually have more money and more power than our state governments. So clearly, I'm on all fours with you, sir. We need more devolution of power to the states. And as I said earlier, the Constitution permits that. Cooperative federalism is allowed.
Thanks, Prof. We received a question from Elisa about is the only way to address the problem of federal-state disparity is through amendments made in Parliament. Right. So I think we can start with the broader questions and then we can narrow it down to the specifics.
Now, actually, amendments is one way of doing it, but the other way would be to use the constitutional provision for what I mentioned earlier, cooperative federalism. That is perfectly permissible. Another technique would be this: pass a federal law, in the federal law, delegate or devolve. Like the way England does, they pass a law at the Westminster Parliament, but in the law, they give the power to the regional government. Would you believe that in England, police is a local function, not a central function? Education is a local function. Housing is a local function. There is nothing to prevent the federal parliament in specific areas by passing federal laws, devolving powers to the states. There's no hurdle whatsoever. The main issue here would be, should it be devolved? Because in devolve, you give, but you can take back. In delegation, you delegate to me, but you can take back. Should it be devolving, or should it be a constitutional amendment transferring the power constitutionally to the states? I think that is a long-term thing. Initially, we can go for cooperative federalism under Article 76, or we can just pass laws, ordinary acts of parliament and Putrajaya in Kuala Lumpur, and delegate powers to the state governments.
So, Prof, we have a question from Liana Karudin here. Prof, you encourage decentralization, but won't such measures devolve federalization in the first place? Why form a federation when each state will have its own power? I guess there's a question of balance and all that. If I may add to her question, Prof, I mean, a bit of historical context. What were the great controversies at the early stages of the writing of this constitution? If you can elaborate on that, as in, weren't there anyone arguing that we should be a centralized state? I mean, at all? I mean, was a federation always at the top of the options available?
Thank you. Yeah, I fully agree with you that the issue is one of balance. In Malaya in 1957, there were no compulsive reasons to adopt a federal system of government. Very small country, territorially. You can have breakfast in Arau and you'll still be in time for dinner actually in JB by car. I'm not talking about, it's a small country, north, south, east, west. Of course, Sabah, Sarawak is different, of course. So it's a small country, and unlike regions like Kashmir in India, whose autonomy was recently destroyed, last year destroyed, or regions in Canada, where the French-speaking population wanted a lot of autonomy. We didn't have such compulsion. There was general agreement that Bahasa Melayu, the Yang di Pertonagong, they will all be common features of the country. But, Chishariman, the issue was how to accommodate the 9 Malay sultans in their territory. So I think that was one strong factor for a federal system of government, to accommodate the 9 Malay sultans, plus the constitutions of these states. A second factor was that some of the states, like Negri Sembilan, have their own adat laws, and they wanted to maintain their separateness or uniqueness, if I may put it that way. A third factor was that there was some historical experience of a loose federal arrangement amongst the federated Malay states. Historically, there was. And some people say a fourth experience that was relevant was that in Negri Sembilan, the 9 regions were actually taking turns to rule the region in a way that reproduced itself with the position of Yang di Pertonagong. So the example of Negri Sembilan, the example of the federated Malay states, then of course adat in many regions, and the issue of the most important issue was actually the 9 separate sultans who wanted to preserve their power over Islam and over Malay adat, and of course their prerogatives. But I would agree with you that on the economic, on the social, on the educational, on the development goals, there was really no compulsion for this country to go federal. That is why the Constitution is predominantly Some say, Mr. Chairman, it's a unitary constitution with some federal features. That's what some people say. Some say it's a quasi-federal. Some say it's a unitary constitution. That's a matter of nomenclature. So the question from Diana was, if you want to decentralize, then why did we begin this way? Actually, even in a decentralized federal system, if you have a federal system, there will definitely be some issues which have to go to a central government, like foreign policy, war and peace, armed forces. Those are obvious issues for federal control, foreign policy, defense of the federation. But as I said, in development issues, educational issues, housing, forestry, there was really no compulsion to go federal. But we did because of the factors that I mentioned earlier. But different countries have different systems. There are, as I mentioned in the very first slide, the 25 or so federal systems have quite a lot of differences amongst them.
I guess what Liana was trying to ask was, would decentralization end up undermining federalism itself? In the sense that maybe is there a risk of going a bit too far? An example that possibly comes to mind is the UAE. Essentially operates as seven autonomous emirates. And so that is quite on the very, very decentralized form of federation.
I can't really answer that question adequately because that question involves a little bit of either this or that, no middle path. I don't think life necessarily operates as either or federal or unitary. There are middle paths, and I think Malaysia was a middle path. Even if we decentralize external affairs, I'm looking at Schedule 9, external affairs, defense of the federation, internal security, civil and criminal law, federal citizenship, all this would still remain in federal hands. But when it comes to finance, trade and commerce, housing, shipping, navigation, fisheries, I think we could give to the states which have a big coastline more freedom to build their ports. So I think we can arrive at middle paths. I'm all for middle paths. I don't think there needs to be a black or white, this or that. This dichotomization, either you're federal or you're unitary, need not exist actually. We can have middle path. I think Malaysia was a middle path, but it hasn't worked that way. The centralization tendencies, because the same party was in power all this while from 1950, in fact not just 57, 2 years before independence, from 1955 till 2008. Same coalition was in power, and therefore actually they did what they wanted. Thank you.
Well, I was just going to add on from that last bit that was a bit more political and add on to what Thomas had asked about politics today seems to have superseded legislation in federal-state relations in favor of the former, so federal. If federal political stability remains at the mercy of defections and whisker-thin majorities in the foreseeable future, could we see states and their rulers using politics to claw back some of their rights, or perhaps even go beyond their constitutional remit? It's by Thomas Daniel, just reading out his name again, so the cops know who to look for.
Thomas, this is definitely what is happening. What you have observed actually is very much in operation right now, and it's bound to increase. This country was unique in the sense that for the entire period from 55 till 2008, the same party was in power. This rarely happens anywhere else in the world. That's why you're right entirely, politics had trumped the law. The constitution was not really being properly observed. Even where there are differences between the states and the federation, these were resolved behind the scenes between partisan national partners instead of going to the courts. You know, in other countries, Mr. Chairman, the states fight with each other over river water and they go to the courts. They fight over roads. Here, except Kelantan Kelantan twice, 63, 65, and Sabah has gone to the court a few times. Most of the time, the disputes were were resolved politically behind the scenes. But yes, with the governments which are not having a bulldozer majority, a massive majority, the states will grow more powerful, will demand more and more. I gave the example of Sarawak suing Petronas and the Prime Minister in agreement with Sarawak and wanting to give them 470 million or so. I think these demands will increase not only from Sabah Sarawak, but from other states. Yes, that's the way politics goes. Politics always sniffs out opportunities, and I think I won't say unstable, because I have to mention this to you. Many governments around the world have razor-thin majorities or even no majorities. There is a phenomenon called minority governments. Our neighbor Australia, actually during the premiership, what was the name of the lady Prime Minister? I'm sorry, I forget. The lady Prime Minister two Prime Ministers ago. Two Prime Ministers ago. She didn't have a majority. She was short. There was equal number in the House. So 2 independents or 3 independents supported her. And so she hung to power, clung on to power with the support of 3 independents. So I think this kind of minority governments in Scandinavian countries, minority government, but your observation is entirely correct. Politics will determine federal-state relations much more than the law. Helen Clark, maybe, I'm not so sure. Helen Clark, yeah. I fully agree with the statement by Thomas Daniel.
Well, there are a lot of all questions here. Basically, Sarawak has, Sarawak all questions have really prompted a lot of questions here. Basically, Prof, they're essentially asking you to elaborate on how do you see this moving forward and whether Petronas should actually go all the way to the federal court for a decision on this matter. And, yeah.
Yeah, sure. I think going to the court is a civilized, democratic way of resolving disputes. You know, one doesn't have to go to the court in litigation, A versus B. The Parlembagan has a friendlier way of getting a court decision. For example, under Article 130, there is something called advisory jurisdiction of the federal court. What the government can do is advise the Yang di Pertonagong. Yang di Pertonagong refers the matter to the federal court for an advisory opinion. So there is no need for Sarawak to sue Petronas or Petronas to sue Sarawak, advisory opinion. But to me, going to the court is a civilized way of resolving disputes. The courts will act impartially and give a decision. So as to your issue as to how we should go forward, the first step, of course, should be to strengthen the consultative processes. The Constitution has many of them in place, the National Finance Council, Land Council, but they have not operated impartially and neutrally in the last few decades. I think these councils must operate more neutrally, more impartially. JPA and the others must operate more neutrally. So that should be the first step, a spirit of discussion before decision. I think is the sine qua non, essential prerequisite of democracy. That should be the first step. But if that doesn't work, then go to the court by all means. And the court will give a decision.
It's pretty clear where you would end up.
There are actually quite a lot of arguments, Shariman, on petroleum, arguments on both sides. You put two lawyers in a room, you'll get three opinions. There are Sabah Sarawak lawyers who say that we have pre-Merdeka agreements during the British times about petroleum, about what our territorial waters are, about the ownership of. So they are relying on agreements during the British times. Now, I'm not making fun of them. I think the issues are complicated. Actually, any issue in law, with all due respect, any issue in law can have two sides. So I'm not pretending that there are no two sides. I gave my superficial opinion, though I'm open to further enlightenment on this. The Constitution is quite clear, and I have a copy of the Constitution here, Schedule 9, I think it is item 8J. 8J. Oil and oil fields are in federal hands, subject to item 2C in the state list. And what is item 2C in the state list? Item 2C is permits and licenses for prospecting for mines. So permits and licenses are in state hands. But the oil, the oil is in federal hands. So that's my view, but I am prepared to be corrected on this point. But when it comes to sales tax, I think Petronas is challenging it, but I think Sabah Sarawak have a good case there, because it's very clearly in Schedule 10, very clearly there is the item called, this is Schedule 10, Part 5, state sales tax. It doesn't sales tax on what? So they can have sales tax on everything from a burger to a barrel of oil. Yeah. Thank you so much.
Overlap. There is a question of this overlap situation. Question involves question involves protected areas have elements of land and forests, which is state list, and wildlife and national parks are in the concurrent list. Since it is not mentioned, does this mean that the executive can define what is a protected area and what is not? I mean, essentially the broader question is, who gets to decide the definition of items that are not defined in the list?
Well, the answer to who gets to decide is only the courts have the monopoly of making such decisions. If there is a dispute, and I think this dispute should well go to the courts, I fully acknowledge there are many issues where there is an overlap. For example, environment is in federal hands, but rivers, forests, farms are in state hands. But surely farms, forests are part of environment, isn't it? River within the state is in the state list, but if it's an interstate river, then that's federal. So these are issues where it's not easy to say this is federal or this is state. In every federation, these problems arise. And the answer to the question would be, if you cannot work out a compromise, well, then you have to go to court. You have to go to court for a constitutional interpretation. Alternatively, as in a spirit of compromise, you could possibly amend the constitution to provide for a clear definition. One could say land and forests subject to wildlife and national parks. So either a compromise, again, or a constitutional amendment, or go to the courts. Courts will make a decision. The court decision need not necessarily be right, but that's it. Once the court decides, that's the way it is. For example, in the Bakun Dam case, Bakun Dam was going to be built, and the objection was that the builders were not satisfying the Environmental Qualities Act, EQA. EQA has a lot of safeguards for the environment, etc. So but the court held that the EQA will not apply. Instead, Sarawak's laws on the issue will apply. That's why actually Bakun Dam was able to proceed much more rapidly than it would have otherwise.
Where we come? Why do I have to read out the religious questions? Yeah, I get the one. I'm the one who gets hauled up, right? Prof, we have a few questions here about religious laws, right? Archana asks, he mentions that we have seen practices of Sharia law in states like Kelantan, and he asks whether states can enact religious laws and practices like Sharia law, which are not seen in the federal laws. If yes, how can the government, I'm not sure which government here, reach a common ground as to this issue? Something that's slightly related as well about religious laws was asked by Yasmin American about how do we balance federal and state power in relation to compelling men to pay child support when the, what's movie?
No, you're moving.
All right, when they move from one state to another to escape their responsibility.
Yeah. Islam is clearly in state hands, but not the whole of Islam. Apologies if anyone is offended. 25 topics of Islam. 25 topics of Islam in Schedule 9, List 2, Paragraph 1 are in state hands. These are primarily issues of family law, marriage, divorce, dower, and nafka, and such issues of Islamic family law. It's a very big paragraph actually, but Islam is clearly in state hand. So if the first question is, can the states pass laws which are not quite in sync with the federal territories law in Islam, the answer has to be a very clear and loud yes. The states have the power. That's why actually we have 14 separate Sharia laws on family matters. Each state has its own law, plus Wilaya, Persekatuan, Labuan, and Putrajaya have one federal law. And may I point this out to you, since the 80s, the federal government has been attempting to pass a uniform Muslim law on family matters. They drafted something in fact, not 80, 76. They drafted one, they sent to all the states. Not a single state accepted the federal model because the states are jealous. The states are jealous of the right to pass their own Sharia laws. And please don't forget, the sultans are the head of the religion of Islam. The sultans don't want their authority undermined. Even during the British days, this one rule was like a rule written on stone, that you don't disturb the sultans in terms of their power over Islam and Malay Adat. So I'm sorry to report to you that on matters of Islam, the state laws have autonomy and the states cannot be compelled. However, there is nothing to prevent the the states from agreeing to allow the federal government to pass a uniform law, and then for the states to adopt that uniform law. But federal by itself cannot campur tangan, cannot interfere in Islam. If the federal government does that, that law is unconstitutional. The federal government may get angry and say, what is this unsatisfactory situation? 14 separate laws for 20 million Muslims. No, we will have one law. So they pass one law. I'm afraid this law has no effect except in Wilayah Persekutuan and Labuan and Putrajaya, because the states have their own law. But if the states give permission to the federal government and then they adopt the federal law, then we'll be having. Now I come to the second issue. Because there are different laws in different states, there is this problem of non-enforcement of the judgments, Sharia court judgments in one state. They cannot be enforced in another state. So the Malacca Sharia court ordered the husband to pay something, but the husband is residing in Kuala Lumpur. He doesn't pay. Now, to me, this is a problem that actually the states can easily resolve. The states can get together, amend their own Sharia enactment, but this will require an enactment in a reciprocal way and force each other's judgments. This is something that is easily achievable, but it will require. At the moment, Malacca Sharia Court has jurisdiction only in Malacca, not outside. But if all the 13 states were to pass a similar reciprocal law, that they would enforce a judgment of a Sharia court in one state will be enforceable in another state. The main difficulty I foresee here is this: if in your state Adat Parpate applies, and in my state Adat Temanggung applies, then why should the Sharia court in the Adat Temanggung state enforce Adat Parpate? So I think that would be a problem. But my heart goes out to this problem raised, the child support, and not only just child support, sometimes actually support for the wife or for the divorcee during the period of Ada. It's not paid. Promises are made, and these promises are not kept. I think the plight of Muslim women is something that must arouse the indignation, the concern of all of us. The plight of divorced, abandoned women, abandoned children is something that really is an issue that is the concern for all Muslims and for all people who support human rights. I'm sorry there is no simple solution here right now, because legally speaking, Malacca Sharia law applies in Malacca. It doesn't apply in Kuala Lumpur. And there is this problem. In fact, the problem sometimes can be much more complicated. A Malacca guy married a Johor girl. They got married in a third state. They got married in Kuala Lumpur because they were working here. Now, which law applies? Which law applies? My answer would be actually the law where you got married would apply. The law where you got married should apply. But sometimes what happens is, they have divorced or they have separated, one of them has gone to another state. There's no simple solution to this question of non-enforcement of reciprocal judgments. There is no problem, but I'm sure we can find one, and I must say this, we must find a solution to this.
With that, I think we are out of time. We have 2
Okay,
minutes to 11:30. So before formally closing today's public lecture, I would like to once again thank the NOAA Foundation for their generous support of the Tun Hussein Onn Chair in International Studies at ISIS Malaysia, Professor Shad Saleem Faruqi for his insightful presentation on federal state legal discourses, and to our viewers for tuning in. A recording of today's public lecture will be uploaded to our YouTube channel soon, and the PowerPoint deck will be uploaded to our website www.isis.org.my in the soonest. With that, thank you and have a great day, everyone.